Hi, I'm Erin Birt at Birt Family Law. And about 5 years ago, I did a video about tips for the final divorce hearing. And I thought 5 years is a long time. So I'm going to go ahead and update that video so that you can have some updated tips for that final divorce hearing for 2025. Now, that video has a lot of valid information. If you have an in-person hearing or even a Zoom hearing, you're going to want to follow the tips that I presented in that last video. But if you are getting a divorce here in 2025 or beyond, and you are concerned or you are worried, and you've got a divorce hearing coming up and you don't know what to expect, and maybe you have an attorney that doesn't have the same philosophy that I do, that maybe sharing too much information or over-educating my clients. Well, you're in a good place. Here we are going to talk about what the prove up hearing means in the divorce world. Now, you might have worked with me or somebody else through mediation. That's where two parties come together with a neutral divorce professional to resolve and discuss all of the issues in your divorce so that you can ask a judge to grant you a divorce. So you all, if you go through mediation, if you go through collaborative divorce, if you go through just uncontested divorce proceedings or negotiations, all of you will face a final divorce hearing, and that is called a prove-up hearing. You are going to present your final agreement to the judge, and you are going to prove up all of the facts and agreements that you've reached to the court. So you are letting the judge know that you filed a petition for dissolution of marriage, that you did some basic financial disclosures, that you talked about and resolved your parenting matters, and that you have all of this written down in such detail that you want the judge to know about it, you want the judge to hear about it, and ultimately you want the judge to approve your petition for dissolution of marriage and enter your settlement agreement as if that is the judgment that the judge would have given you if you presented all of these facts at a trial. So at a final divorce hearing, when you have reached agreements on all issues relating to parenting time, parenting decision-making responsibilities, and then the allocation of assets, debts, and liabilities, and the financial support for your former spouse or financial support for your children, when you get all of those details worked out, you're still going to have to put it in writing, and you're still going to have to go see a judge to make sure the judge approves it and signs off on it. And that, folks, is the only way you're going to get a divorce.